Welcome to the Trade Secrets. Intellectual property is one of these issues that touches everybody. This series is designed to help bring light to what this law is and how it works. That's troll for hello. While we sit here today to discuss copyright infringement, our camera is making a copy of the troll, itself a copyrighted work. If we don't have permission of the artists, we're committing copyright infringement because we're making a copy. Now there is a defense, and that's what we're going to talk about today. It's called de minimis copying. De minimis is Latin for trivial matter. Now, as a threshold question, I've got to ask, is our copying of the troll a trivial matter? To answer that question, we need to understand two things. First, what is the law of de minimis copying? And second, how does this affect the artist's rights? The question of de minimis copying itself is somewhat ironic. When is copying not copying? I swear, only lawyers could come up with this stuff. Let's look at an example of how this works. Remember the movie Seven with Brad Pitt and Morgan Freeman? Well, about 1 hour and 18 minutes into the movie, some photographic transparencies show up in the background. The photographer who took those pictures sued New Line Cinema for copyright infringement. Said, "You made a copy of my pictures in your movie." New Line said, "Well, we made a copy, but we think it's de minimis." They argued it was only in the shot for about 35 seconds. They were partially obscured, somewhat out of focus, never a primary part of the movie or the shot, and an average lay observer would not be able to identify the photographer's pictures from that scene. The court found it was de minimis and okay. Another example is the movie What Women Want with Mel Gibson. In that movie, there's a scene with Mel Gibson and a pinball machine. The pinball machine is in the background. The copyright owner of the pinball machine sued the movie company. Said, "You made a copy of my copyrighted work without my permission." Like in Seven, the movie company said, "Yes, your copyrighted work is in our movie, but the use is de minimis." The court looked at it and they said, the silver slugger was out of focus, never a primary shot, not mentioned by the characters in the movie. Importantly, the court said, an average lay observer would only recognize this as a generic pinball machine and not as the specific work of art related to the silver slugger. And so it was de minimis use. The de minimis argument does not work all the time. In the sitcom Rock, a copyrighted quilt was shown in the background. The quilt in this case appeared in the shot for about 30 seconds. The artist of the quilt sued for copyright infringement. The defendant said, "Hey, this is de minimis." The court disagreed. The court found the quilt was displayed in its entirety in the background of this shot. It showed up for 36 seconds, and the art was recognizable. The characters in the art were recognizable, and the artistic style of the artist himself was recognizable by even a lay observer, and therefore it was not de minimis use. In summary, de minimis use really seems to come down to a few factors. Is the background art in focus, in frame? How much of it is there? And would a lay observer understand whatever the art is to be an artistic work itself? But what about the troll? In the next episode of The Trade Secrets, we will talk to one of the troll's artists and find out if our use of the troll is indeed de minimis.
For more information about this series, visit us at thetradesecretsofintellectualproperty.com.